Ladies and gentlemen, we're 5 minutes behind, but I think that's pretty good considering. My name's Alan Babel, for those of you who aren't here, who weren't here for the first continuation of the March general meeting. What's that? Yeah, well, now we are on our second annual general meeting. This is a special general meeting that was brought forward by the Board of Directors. I'm just going to reiterate for those people who did show up and we're not here. If you are just showing up, make sure that you do register over here. We want to make sure that you're signed in and you have a voting placard. And so we know that you've been in attendance. I also want to remind you that typically the feds will have 2 general meetings. They have one in October and they have one in March, when most of the students are on campus and as scheduled on an annual basis. So this is an exception to that rule. The board felt that there were items that needed to be shared with the General Assembly, and so we will discuss them. Our current, I also, some people are really sticklers about voting and stuff. I'm going to take it as friendly that I'm going to continue as your chair. Okay, so I'm just going to continue on as speaker for this meeting unless anyone opposes that. Some people might. They voted against me in the last one, but I'm not pointing any fingers. That's okay. I'm calling the meeting to order, yes. The meeting is called to order. Just like to joke around. Sir, you have a motion. Unfortunately, at this time, what is your motion? What is your motion, please? No, there are no motions. Unfortunately, because it is a special meeting of the General Assembly, we cannot entertain motions or amendments at this time. They called a special meeting. Sorry, what was that? In the green shirt? Okay. My understanding is that any special meetings of the General Assembly called by the Board of Directors cannot receive any further amendments or motions. My decision is to move forward with the agenda as you see here.
I would like to motion to appeal the chair's ruling.
You may technically do so.
I am doing so.
Okay. Do we need a seconder? Sure, Jesse, why not? Yeah, that's good. Okay, would you like to speak to your motion?
This isn't a special meeting. It's a general meeting that the board called, so motions can be brought forward. So I have a motion that I would like to bring forward.
Okay. Is there anyone who would like to speak to that? Speaking again to whether I'm in order or not.
Devin Drury, VP Internal. Our lawyer advised us, because we did call this as a board as a special general meeting. Like it's not in the bylaws. He said that means it's a special meeting, which means only what is on the agenda can be entertained. And because that's a yes or no decision, the chair does not have to be challenged.
Thank you. I believe that clarifies our stance on the decision. So we're going to continue on as planned. You're challenging. My understanding is a regular general meeting occurs in March and October as stated by the bylaws. My understanding of the interpretation of the bylaws is that anything outside of a March or October general meeting, which we can all agree this is not, July, this is deemed a special meeting, and therefore motions and amendments are not allowed on the agenda. Sir. The interpretation of the bylaws, you're going to have to pause on that. I'm being told you would like, as a General Assembly, to vote on whether or not your interpretation of the bylaws is correct. Is that correct? You'd like to...
general meeting may be called. All right, so our bylaws say in section 5A, timing, the annual general meeting, blah, 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 October, general meeting shall be held, blah, 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 March. At any time, a general meeting may be called by any one of the following, which includes the board of directors.
Right.
So this is not a special
So
general meeting.
does it say
It's
anything
a
about
general
calling a
meeting.
special general meeting?
No.
So that language isn't used in that,
No.
right? Which we would then assume that any meeting outside of our regular meetings would be a
No.
special.
According to the bylaws, this is just a general meeting because we don't have language for a special general meeting, and we can call a general meeting.
Apparently we are. I would appreciate that. We're paused for one moment while the executive consult how we will proceed. I will not be, someone take the mic. Session is paused. Session is paused, please. Go ahead, Sean. What's that? You may.
I've got things to talk. All right. So the question before the assembly is whether or not this should be considered a special general meeting, and whether or not we can entertain new business. I don't think this is an easy question. I don't think, and so I'm going to do my best to interpret our rules by my interpretation. I think that we should be, I think that this discussion here should be a procedural discussion only. As much as I hate procedural discussions sometimes, we need to be focusing on whether or not this is allowed. If we don't like it, then we can deal with that separately. Okay. There we go. If this is a question of whether or not we want to have items that are brought up without notice, that's something that we can deal with later. This meeting has the power to adjourn by a majority vote instantly at any time. So the question we have is whether or not this is allowed. So Robert's Rules of Order is our parliamentary authority. It's defined by the bylaws as defining how we conduct our meetings, and it says, a special meeting or called meeting is a separate session of a society held at a time different from that of any regular meeting and convened only to consider one or more items of business specified in the call of the meeting. So I think here we need to use the duck test. Does it walk like a duck? Does it talk like a duck? So the two questions we need to answer are, is this a meeting that is held at a time different from any regular meeting? And is this convened only to consider one or more items of business specified in the call of the meeting? So I do not think that the title of the meeting, the exact wording of the bylaws, matters, because the title of the meeting is just what someone decided to write there. It's not necessary, whoever wrote that up there could just as easily have written July special general meeting. And if we're basing our decision on that, I think that's a rather poor basis. So I think that we do have, this is a time different from a regular general meeting. It's not March, it's not October, and we aren't continuing either of those meetings. So I think that test is met. Now the question is this a meeting called to consider only one or more items of business specified in the call of the meeting? That's a really hard question to answer. Our bylaws state that generally there's no restriction on, the bylaws do not impose a restriction on business to be transacted at the meeting, so we can't obviously tell whether or not this is a special meeting. However, the bylaws do say that that the Act, which is the Corporations Act, which defines the Federation, may restrict the business that may be brought forth without notice. I helped write that provision, and this was intended to be looking forward to the new Not-for-Profit Corporations Act, which unfortunately the Government of Ontario delayed from taking effect, so we're still using the old law. But under the new Not-for-Profit Corporations Act, only a few types of business, such as election of directors, reappointment of the auditor, and one or two other things can be considered without notice at any general meeting, special or otherwise. And so in that context, you're welcome to have different opinions, because I'm not entirely sure of this opinion, but I think that the provisions in the bylaws should be interpreted as being permissive, that new business can be brought forward, And so because of that, because this is not a meeting that is called explicitly to cover only one or more items, it's not considered a special meeting, and therefore these motions will be in order. I don't think that that means we necessarily need to need to be happy that they're being brought forward, because there is the question of whether it's fair to bring them forward without notice. But I think that right now the procedural issue is that these are permitted. And therefore, I would speak in favor. I would speak to overturn the ruling of the chair. Thank you.
So, my understanding at this time is that should someone want to add new business to this meeting, we are, my opinion of it and what I have been directed to do is to move forward with no amendments to the agenda so we can get through the executive updates and adjournment. However, I've been challenged by our wonderful friend David Birnbaum, which I'll remember forever. It's nothing personal. David Birnbaum has challenged the chair. We've had a seconder on it. I believe he spoke to why you've challenged me. Is that correct? And Sean did as well. Is there anyone else who would like to speak on whether or not I'm correct in moving on in this? I have a speakers list. I'll entertain that list. First, this gentleman here. Sure. Right. I'm going to ask Sean to answer that. Just being the Robert's Rules.
So Robert's Rules, the parliamentary authority, defines what is, defines the rules for a special meeting. It's a series of rules that an organization can use, and we don't necessarily have to use all of them. And so the question is, do we use are we currently in a special meeting, and do those rules apply? Because those rules exist, but it's not, I think the question is, are we using them or not? Does that make sense?
Okay, thank you. Thanks for the clarification.
Hello again. I have received word from our lawyer again, and this is actually a slightly older document from this morning. The lawyer has deemed this to be a special general meeting, which then falls under the subsection that Sean mentioned. And just to clarify for everybody, what's going on here is, well, what can happen is the fact that Robert's Rules actually can be overruled by our bylaws, which then can also be overruled by the Corporations Act. So that's just to clarify what's going on here. But again, our lawyer has deemed this as a special general meeting, and I think that we should proceed as such.
I would advise the president to not try and scare the membership by continually throwing out the word lawyer. I feel that according to Robert's Rules as outlined by member Sean Hunt, a special meeting is a meeting called specifically for an item. This meeting was called by the board and had open submissions. Any member could have submitted any item to this meeting. There was one member submission that is not on the agenda, and then there's executive items. So there were 2 items, but this meeting was specifically called as a general meeting and had any member submissions could have been brought forward. So it is not a special meeting as defined in Robert's Rules. Our bylaws do not define special meeting, and they also do define that the board of directors can call a general meeting. So that is why this is a general meeting. That is all.
Okay, then
So where does this leave me, guys? Oh. Well, thank you. Thank you. I would, I'm trying to weigh what I've been hearing. You know, I was asked to come out to be speaker as a neutral member and a neutral voice, right? So my job here is to make sure this meeting runs efficiently. It is not. I'm not getting clear direction as to the direction that we should be going right now. I would say as the chair that any legal advice that the corporation receives should be taken to heart. as they are your lawyer. My understanding is our lawyer has advised that the Board of Directors called a special general meeting. Whether or not that was posted on this Word document is not necessarily relevant. I am under the inclination that I will continue to see this as a special meeting and therefore not allowing new motions, which means further discussion about things that you may not be aware of to continue on this meeting at this time. My understanding is that any time members of the Assembly are able to put forward motions that they would like to have on the agenda, the next opportunity for that, unless another special meeting is called, would be at the October General Assembly, where any motions that a member of our Assembly right now would like to bring forward could at an appropriate time. That is my understanding of the situation. Is there anyone else, perhaps regardless of the second speaking term, David as president can speak on behalf of what update he has now? All right, I'm out of order. Is there someone else who can speak to what's going on from the executive's perspective? I just did, though. I just need to hear from them. Is that fair? Thanks. This is an issue, right?
Hi, guys. So I just have the statement from our lawyer about why this item had been removed in the first place. Oh, okay.
We don't have to vote on that. Are we calling the question on whether or not I'm correct? Can I get an executive to? Please. Is at this time, we are asking the question whether or not the chair is in order as to whether we can add amendments. Should you vote in favor, you are in favor of moving forward with the current agenda. Should you vote against, you're opening up the opportunity for this to not be a special meeting based on this Assembly's interpretation of the bylaws, and therefore have an opportunity to put forward motions, which we will then discuss in appropriate manner. Does everyone understand? All those in favor of the chair, please raise your placards nice and high. Can I get a counter, please? Thanks, Dave. Verify, what's your count? All those opposed? Okay. All those any abstentions? Okay, motion fails, 61-71. My understanding is the Assembly has therefore interpreted this as a regular General Assembly, therefore is accepting motions. My understanding is that that vote said that I was incorrect. At this time, we have David Collins who would like to make a statement. we're just at the beginning of the meeting. Is this privy? Is everyone okay with this?
Hello? Okay. I'd also like to advise a comment that was directed to me before. I think that when I come to program knowledge integration, and one of the things that we were taught from the very beginning is to always seek out expert advice, and then always make sure you quote your sources. So if I am intimidating others, I sincerely apologize. However, I would like you to know that this is actually me seeking expert advice to make sure that I'm giving you the absolute best information, the most up-to-date information possible. But let's move on from that. Again, I just was off the phone with our lawyer once more. He's a wonderful guy. And his ruling for this is, yet again, it is a special general meeting. And by those provisions, what that means is that we are not supposed to be accepting new items to the agenda. So regardless of whether or not the speaker has actually made this ruling or not. Again, I'm up here to read the statement as well that discusses why the Board of Directors removed the item from the agenda. So again, I will, thank you. Okay, so again, the background to this agenda item is that one member of the Federation of Students has brought forward a proposal to be presented at the special general meeting called by the Board of Directors to be held today. This proposal was accepted pursuant to paragraph 5C of the bylaws in the mistaken belief that it was in order, and accordingly, it was put on the agenda for today's meeting. Paragraph 5C is entitled Proposals, and the first line reads as follows. The board shall include proposals submitted by voting members in the second notice of a meeting in accordance with the Act. However, we have subsequently realized that such a proposal is only provided for by the proposed Not-for-Profits Corporations Act. And just to give a quick clarification to the audience, the Not-for-Profits Corporation Act is both not in effect, and right now we are being governed by the Ontario Statute of the Corporations Act, passed in 1990. And then, sorry, go back to my statement, which has not been proclaimed in force. The Federation bylaws were redrafted this past year, partly in anticipation of the new Not-for-Profit Corporations Act coming into force. And if you'd also like to read along at home, this is actually available on our website. The bylaws provide the references to the Act are to whichever Act is applicable at the time. That means that paragraph 5C of the bylaws must be interpreted in accordance with the legislation that is now in force. In the first line, that paragraph refers to in accordance with the Act. As the legislation that is now in force of the Corporations Act, it is necessary to look at the language of it. Pursuant to Section 296 of the Corporations Act, a resolution can meet requisition by members, but it must be done by requisition signed by 1/20th of the members of the Federation of Students, and not by one member. Accordingly, the proposal is not valid as submitted. In addition, the wording of Section 56 of the proposed Not-for-Profit Corporations Act suggests that a proposal by one member applies only to an annual general meeting, an annual meeting of members, and not to a special general meeting. The fact that this proposal got on the agenda in the first place, the proposal got on the agenda of the special general meeting called for today is unfortunate, but it must be removed for the reasons I previously stated. We regret any inconvenience that it has caused. And this is a statement from our Board of Directors, again, sincerely apologizing for our mistake and oversight in actually allowing this to go forward. What I'm trying to make the point here is, again, this is a special general meeting, and as such, we have to follow those other documentation. So I think it would be best for us to just continue on.
So bearing that in mind, just so you guys were following, David was speaking to a potential motion that is coming forward. That's my assumption. But perhaps there's a different motion on the table. So you voted that this assembly has voted that I am incorrect in not accepting new nominations. You would like to allow amendments and changes to the existing agenda, and therefore I'll open up the floor to welcome that. I believe we have someone who wants to add something. Yes. What's your name again? Just joking.
David. So first, I'd actually like to state that President Collins.
Sorry, do you have a motion?
I have a motion.
Okay,
and a
what is
statement.
the motion?
Fine, I will read my motion.
Thank you.
Whereas the Society's agreement recognizes the societies as entities having independent financing and sponsoring activities, and whereas the recent Federation of Students audit regarding the Engineering Society and its finances has gone well, and whereas the Federation of Students has had a history of extremely poor turnaround times on the Society's fee, and whereas having the engineering faculty handle the Engineering Society money transfer would reduce the workload of the Federation of Students, and whereas the Engineering Society has a full-time business manager that oversees its accounts, and whereas the Dean of Engineering has spoken in support of the Faculty of Engineering handling the Engineering Society's fees, now therefore be it resolved that the Federation of Students actively works towards reducing its workload by having the Faculty of Engineering handle the Engineering Society fees and their transfer.
There's a motion on the floor. Do we have a seconder for that motion? Jesse. Sure. Thank you, Sean. Yeah, here you go.
Is there someone present who has a copy of the agreement with the university as to the general operating agreement as to student representation?
Okay. That's a question, a point of order they're asking. There is a society's agreement in place. Those of you who don't know, the motion is talking about the Engineering Society, one of the, under the umbrella of club services and societies focused on engineering. There is an agreement between the Federation of Students and said societies. We're just trying to track down if that's available. My understanding, though, are there any other points of order on this motion that is on the table right now? Yes. It's a question. Okay, yep, that's fine.
Does the representative from NSOC know how much money we're talking about?
So the question is, how much money are we talking about here?
Our fees are $15.02 per student as of the $15.02 per student as of the fall term, which is about between $40,000 and $60,000 per term. Right now, the university collects the fee. It is provided to the federation, who then provides it to the society. The motion would have feds work towards the fee being provided from the university to the Faculty of Engineering, then to the society, which the Dean of Engineering has spoken in favor of.
Okay, so at this point in time, thank you for answering that. I believe we are motioning to put this on the agenda as a point of discussion. It's just a motion. You're debating the motion itself. Okay, is there anyone, can you pass along the motion so we can see it up on the screen? That'd be great. So we're going to work to get that up so you can view it. At this time, given that there may be other people here who wish to speak to this motion, I'll entertain any questions or comments about the motion at hand. Yep.
Sorry, guys. It's my understanding that in order for societies to collect a fee, it has to go through the Federation of Students. The university will not provide it directly to the society. So if the Engineering Society would like to not collect a fee from the Federation of Students, they will be operating without a fee at all. That's your choice.
So we can, if you could just stay, because we might have a logistical question about that. My understanding, and just to repeat that, there are certain agreements from the University of Waterloo's finance department that allow the distribution of fees and student service fees. What's the name of the fee? The student ancillary fee. When that's collected from you by the university, the Federation of Students is the only organization on campus that can collect that fee and distribute it to students, and they have agreed to distribute a certain amount to engineering, for example. So we've raised a point of concern about operationally, this may not necessarily work out the way that you're hoping for it to. Is that correct? Yeah, okay. Is there anyone else on our speakers list?
Hi everyone, my name is Kevin McNamara. I'm the current VP Finance of the Engineering Society. So in fact, what this motion is proposing is that our fees would, instead of going from the university to the Federation of Students to the Engineering Society, they would go from the university to the Dean of Engineering office to the Engineering Society. So we would still in fact be collecting our fees, it would just be from the faculty. On that similar note, Imprint collects their fees directly from the university as well. The Waterloo Engineering Endowment Foundation collects their fees directly from the university. So we are in fact having our fees go to the faculty, then to the Engineering Society, rather than through feds under the current structure. Thank you.
Okay, we'll continue on the speakers list. Can I just get the VP Finance to comment on the accuracy of that statement? Yeah, just so you're getting the right information. Is that fair? Yeah. Who here is part of engineering, just so I get a sense?
You don't have to say.
Sorry to put you in an awkward situation.
I'd just like to clarify that this isn't mandating it to happen. If this vote passes, it's just feds should work towards it, right? So obviously it doesn't automatically happen. It's saying that feds should work towards it. Obviously they would be working with the Engineering Society and the faculty.
Okay. Okay, thank you. Well, that's what I thought. I thought this was a motion to add it to the agenda, but apparently it's not. Okay, so I'm going to continue on the speakers list. Yes, ma'am.
I'm just wondering why. So to the VPF of NSOC and to the person who made this motion, why do you want to handle your own finances? What is wrong with it being handled through feds at this time?
Okay, I'll ask the VP Finance, who is that initially directed to? Is that this guy? Okay, great. So you can respond to that question directly, please.
Okay, reasons for wanting to do this were outlined in the motion as stated. Where every single term, our fees come to us very late. Having our fees come to us in July after we've had 2 full months of directors handing over their own personal money on their credit cards to run these events does not allow for a good running structure. How can you expect an undergraduate student who's already strapped for cash enough as it is to pay for something at the start of May and not get their money until the first week of July?
He's responding to a question, so you have to give him one.
Does that answer your question? I don't know where she went. Okay, thank you.
Hi guys, my name is Kumar Patel. I was the VP Finance of the Federation for the last 2 years. So not
That's
2 years, the previous 2 full years. And I've written a lot of the checks for each society and faculty student union on campus. Let me tell you, it's not that the feds doesn't want to give it, it's the university doesn't give us the money on day one. Unfortunately, all fees are not fully arranged on day one of the semester. All right, so unfortunately, we don't get it until it's arranged as far as all the students and UW finances goes. We do check and make sure that each society is in compliance with GAAP and not doing anything bad with the money. That's for your safety. We have 3 CGAs in our organization to make sure that your money is protected. And I'm really sorry that it's just the way the system is. That's something maybe we can perhaps take up to the university. But I really do not recommend. I know you're engineers and you guys are all smart, but this is money and the way your finances are handled, and I'm telling you there's systems in place to make sure it's safe. All right? So please, and the other thing, as I said, fees aren't arranged as of day one of every semester, and that's why we can't release the funds.
So I'm going to we have a question for you. Oh, okay, thank you. Okay, Jesse?
So I will speak in favor, just because my interpretation of this motion is for feds to work towards having the money transferred to the faculty to transfer it to the society versus the money being transferred to feds and then transferred to the society. Speaking as this from my personal views, I think it would lessen some of feds' workload because they won't have to be the ones responsible. That responsibility would fall to the faculty. And if the faculty ends up being okay with taking on that extra legal responsibility and legal risk, from my perspective, I think that's a good thing because that's less legal risk on feds. So I don't know. I think, and if NSOC feels that this is to their benefit and will get them their fees faster, regardless of whether or not that is the case, I mean, if there will be a delay because it stops at the delay comes from the very, very top, and it's not happening at the feds level, it's happening at the top level. That's their decision to make at the end of the day. So I would speak in favor of this because it was brought forward by NSOC for NSOC. So, thank you.
All right, Adam, would you like to? Okay, thanks. Is there anyone else who'd like to speak to the motion on the table? Okay. We have a last person. Sure, you can ask a question to feds, yeah.
My main question to feds is why would you want to keep it? What is the difference between MSOC doing it or feds doing it? What's the main issue?
Okay, that's a fair question. I'm going to ask the VP Admin Finance, or the former VP Admin Finance, or the General Manager, one of the three, to come up and address this question. It's a very fair question. So just to repeat the question is, why does feds want to continue to maintain the oversight and distribution of the Engineering Society fee?
So the reason would be that being part of the Engineering Society, you are a member of the Federation of Students, unless you're totally separate, which you're not. That means that we assume liability for you and your actions. By reviewing your finances, we maintain a not-for-profit status as the Federation of Students, which allows us to do a lot of the things that we do. So by overseeing your finances, it's to maintain that status so that the feds can continue to be a service to you. If the Engineering Society decides to split from the Federation of Students, the way I would see it is that all members of the Engineering Society would no longer be members of the Federation of Students and would no longer reap any of the benefits of our services.
Okay, thank you. Thank you. Okay, yeah, that's okay.
I have a few responses. First of all, the last statement by VP Porzega is incorrect. Every engineering student pays a membership fee to the Federation of Students and to the Engineering Society. We're not discussing anything about the Federation of Students fee, so every member would still be a member of the Federation. What this would do is simply, the Engineering Society would still be under the blanket that is feds. All this would do is that the fee would go to the faculty. It has nothing to do with NSOC structure under feds or the engineering students membership. It has nothing to do with either of those. As well, the Engineering Society gets audited as per feds. They can ensure through the audit that we are currently working with them on that we have our not-for-profit status. We have never in our history had a problem with that, so I don't know why that would be highlighted as a concern now, but we do get audited, which would ensure we are in compliance.
Okay, so we're at our, just given where we are in our meeting, we're going to see the rest of the speakers list, and then I'm going to call the question, okay? So you have an opportunity to continue on. Go ahead.
All right, one thing I just want to clear up, that feds doesn't, I've never in 2 years, as I said, have I've never asked the society to spend their money a certain way, right? It's very high level oversight, making sure, again, so we're in compliance with GAAP and in compliance with whatever tax rules and regulations we have, as well as that the society's effectively budgeting and properly presenting their financial statements. Unfortunately, in the last 2 years, I've probably seen 3 or 4 dozen packages basically requesting the society fee, and there have been many errors in which we've caught as far as the way budgets have been presented or the way things are being expensed that were totally wrong. And we're protecting, like we have never told anyone how to run your bake sale, aside from the safety perspective of it, or how to run whatever events you guys run. I don't even know what events you guys run, so that just tells you that we don't have that type of oversight. It's a very high level oversight. It's to protect you guys. I think that if students, and I agree with the NSOC Society presidents, our students shouldn't have to be waiting for their checks to be reimbursed. I think that that's something that we can work with, the NSOC should work with the Federation in providing some sort of interim solution so events can continue to happen. I think that's a proactive way of getting things done, and I think that will be a more effective way in managing engineering students' money. Thank you.
Thank you. My name is Chanakya. Until that time, I've been not speaking. I represent engineering to feds alongside David, and I'm personally in favor of this motion just because I've seen it personally on a one-on-one level, the hardship that directors have to face because of the lack of availability of the funds. And at the same time, like since university is the one who's delaying, if faculty is the one who's collecting from their financials, then we have a bigger sway because the dean of engineering wants the money, she'll get the money. Thank you.
So I just want to say that if a faculty wants to, or a society wants to do that with their fee, it should really be up to them and not as much the Federation of Students. If MASSOC, I'm a former exec and future exec of MASSOC, if we wanted to, I would hope that feds would say yes, but that isn't obviously the case for us. But if you guys are interested and if engineering is willing and that's what they're going to pass at a general meeting, I think feds should accept that.
I'll be chair. Sit down.
I'm still here. I'm still here. Don't worry. Okay, I'm pretty sure we've exhausted our speakers list. I'm just trying to determine what our vote is for this. Why, can you guys just help me understand why this wasn't added to the agenda? I know. I'm just trying to clarify why this wasn't added to the agenda originally. You do not need to specify why it was added, why. No. But we were discussing adding this to the agenda, which is. Just answer me. Right. Okay. So that affects the vote count. Do you see why I'm asking? It's 2/3 to add to agenda. It's not 2/3 to have a motion. Right? Right. Okay. Thank you for that clarification. I'm getting mixed messages, so. Do I have any update, or are we calling the question? Okay, we have one final speaker. It might be me. All right, some people are getting a little pissy because it's late. Ladies and gentlemen, seeing as the speakers list is exhausted, we are calling the question to vote on the said motion at hand. Are there any objections? I'll read the motion once. Whereas the Society's agreement recognizes the societies as entities having independent financing and sponsoring activities, and whereas the recent Federation of Students audit regarding the Engineering Society and its finances has gone well, and whereas the Federation of Students had a history of extremely poor turnaround times on the Society's fee, and whereas having the engineering faculty handle the Engineering Society money transfer would reduce the workload of the feds, and whereas the Engineering Society has a full-time business manager that oversees its accounts, And whereas the Dean of Engineering has spoken in support of the Faculty of Engineering handling the Engineering Society fees, now therefore be it resolved that the Federation of Students actively works towards reducing its workload by having the Faculty of Engineering handle the Engineering Society fees and their transfer. Period. Point of order?
The Federation of Students is currently going through its audits. How are we saying that the engineering audit has gone well? Has the audit been complete and released?
Okay, question wasn't called. I said call the question. They're saying we have to move forward because I called the question. There's a point of information. Okay. So that you guys, I'm just going to take this opportunity to say you have been provided with many different perspectives. Many of you came here perhaps with a particular goal in mind of having this move through. My opinion on it isn't relevant. I'll remind you why you're here today. The General Assembly is here to make high-level decisions on behalf of all of the students here on campus, including engineers. There are a number of mechanisms set up within the Federation of Students, including Students' Council, the Board of Directors, the 30-plus full-time staff, and your executive committee, who are all mediums in which items like this are discussed on a regular basis. As a General Assembly, should you be making this decision, you are considering the fact that all of those different members have just spoken to you. It does not seem black and white, and therefore we need to have a vote. As is, I call the question. All those in favor, please raise your placards. Can I have a counter, please? Any abstentions? Nice and high. Anyone who would like their abstention noted? Yes, you'd like yours noted? Okay, we got the VP Finance and Ryan Camping? Ryan Campagnola. That's a sweet name. You should be chairing this meeting. All right. Motion carries 65, 50, and 4. So motion carries. Okay. Unless there's anything else, yes. Where's my mic? I have a motion on the floor.
I would just read the motion.
Yep.
Hi, everyone. My name is Kevin McNamara. Whereas the Board of Directors has acted against the best interests of the corporation by amending the agenda the day prior to the general meeting, resulting in immediate and lasting damage to the corporation's good name and reputation. And whereas it is legally required to keep the CEO on the Board of Directors under the Ontario Corporations Act 1990. And whereas the vote to approve the member submission was recorded. Now, therefore, be it resolved that the voting members of the Board of Directors who voted against approving the member submission, disallowing its consideration at this meeting, Prashant Kumar Patel, Adam Garcia, Natasha Pozega, and Devin Jury be removed immediately.
please speak to it.
It's a non-debatable motion, requires 2/3 to carry, and kills the motion instantly.
He has spoken. Sean, can you explain what just happened? Not that I don't know, but I'm just, making sure that everyone else here does. Give Sean a moment. Sean, can you just say that a little slower?
My motion is the objection to the consideration of the question. It's non-debatable and requires a 2/3 vote. If it carries, the motion cannot be brought forward.
So you are proposing a motion at this point in time to dismiss the previous motion?
Yes.
That motion requires 2/3 in order to continue to hear the
No,
motion.
it requires 2/3 to kill it.
2/3 to kill it. So if
Yeah.
2/3 of the members in here vote yes, they are saying we do not want to talk about this motion. That's correct. It's non-debatable. I must call that question. Just to repeat, you have been now, Robert's Rules, seen it at its finest. One moment. Robert's Rules is indicating that there is an opportunity for a member of the Assembly to vote on whether or not this motion can move forward. Requires 2/3 to move forward. 2/3 to move forward, right, Sean? 2/3 to stop the motion. Point of clarification. Yes, we can do a count to see how many people are here to reflect what 2/3 is. Two-thirds, I don't know, it's probably 2/3 vote. So, okay, all right, so. This is why they pay me the big bucks. Like ice cream. That's what I got. That's what I got, ice cream. Is there deliberation on this, or am I calling this question? Not debatable. Right. So we understand that if you vote in favor of what he is saying, then we cannot discuss the previous thing brought forward, right? We all get that? So if you don't want to have any discussion, vote yes. All those in favor, please raise your placards. You're voting, the motion is to remove executive, right? So like, to kill the question, this is to kill the question, right, sorry. If you vote yes, the motion dies to ask the question. Can you guys help me count, please? Okay, all those opposed? Seems like to me you're voting as a block. Any abstentions? 2 abstentions. No, yeah. There are 5 abstentions. Do you want yours noted? Okay, so The motion is 59-49-5. So where does that put us? Motion dies? What's that? It's not 2/3, yeah. All right. So we're at the original motion, and we had a seconder for that. Can we get, yeah, is there a point of? We can, yeah, we'll have to get it put up on the overhead. So the mover of this motion, yeah, there you are. Can you just pass that on to her? And we'll start a speakers list.
Are we at speaking turns right now? Mr. Chair,
Oh, I got a copy there. It's okay.
if there's no objection, I'm willing to start speaking without the motion on the board. All right. First off, I want to say that I believe that this motion should not pass at any cost. This is a serious motion to remove almost half of the directors of the corporation. This meeting is questionably called. This meeting decided by vote that it is properly constituted as a regular general meeting and that any business can be brought up. However, this decision can be challenged in a court of law. If we remove 4 directors, I would expect service on the corporation in the next week of a lawsuit to declare this motion, or this general meeting to be a special meeting, and this motion to remove the directors to be invalid. I do not believe that it is in the best interest of anyone to have this lawsuit go forward, because we will then feds will have to spend a lot of money defending this, or it won't, and the entire thing will be moot, like the feds will just yield and the entire thing will be mooted. I don't think this is at all in the interest of the students. Furthermore, I don't think that this meeting is being very productive. A decision of this scope should require notice. As much as I think that it doesn't, I do believe that it definitely should, and I do not think that a motion of this kind should be brought forward without notice. So with that in mind, I don't think that this meeting is being productive anymore. Therefore, I move that we adjourn.
We're going to pause the meeting for a minute just to make sure we have the best advice possible for this. Thank you.
Ladies and gentlemen, I'm on the mic. I have with us here our lawyer. It's not a laughing matter. The reality of what's being proposed right now is very real and is not allowed. We're going to hear from our lawyer about why this provision is not going to be entertained. I'm going to ask that you respect what he has to say. I'm going to try doing speakerphone, but if not, I'm going to repeat what he says. We're going to try to hook him up. Thanks, Gary. Pay you the big bucks for this. So we're just going to try plugging in the phone. And,
Yes, sir. You hear me?
So,
Can you hear me? Thank you. The executive under your at large. Okay. The executive under your bylaw.
sorry, that wasn't working. If you'll speak, I'll repeat sentence by sentence. The executive are elected under your bylaws by the membership at large in elections for a specified term of 1 year. The bylaw does not provide any provision in which the executive can be removed between their elected time. That does not mean that under the appropriate circumstances that there is not mechanisms for a removal. However, any such decision would require sufficient notice to the members of the executive in advance of the meeting in which this would be heard. That is why a motion of this nature cannot and will not be entertained at this meeting at this time. Gary's been with the Federation of Students since 1977. Are there any questions for Gary moving forward? If not, I intend to continue on this meeting with our current agenda. Do you have a question? The question is,
I felt like what the lawyer was said was that they can't be removed from their positions, but can they be removed from board?
the question is, can they be removed from the board at this meeting? No. That was a good answer. Okay, I'm just going to put you on hold, Gary. Therefore, we will be continuing our meeting as planned. Motion to adjourn. Can I get a seconder? I see Brad Crane in the back. We're not speaking to this. It is a vote. All those in favor, please raise your placards. Okay. All those opposed?